In a legal battle where lives hang in the balance, the sheer volume of preliminary arguments can be staggering. In the case of State of Tennessee v. Gary Wayne Sutton and James Dellinger, the defense filed a combined total of over 90 pretrial motions, meticulously challenging almost every aspect of the state's case before trial even began. This level of legal scrutiny raises fundamental questions about due process, judicial economy, and the very structure of capital punishment. James, what were some of the most contentious motions brought before the Blount County Circuit Court on that day in April 1994, according to this transcript of proceedings?
William, it's clear from the transcript that the defense teams for Sutton and Dellinger left no stone unturned. The motions covered a wide range of issues, from suppressing evidence to challenging the constitutionality of the death penalty itself, and even demanding separate juries. The proceedings began with counsel, Mr. Gibson, noting the immense number of motions already filed, 35 for Mr. Sutton and 56 for Mr. Dellinger, plus a couple of new ones. These weren't just procedural filings. They were substantive challenges aimed at shaping the entire trial.
And the first major argument the court took up was an amended motion regarding the unconstitutionality of the death penalty. What was the core of the defense's argument there?
The defense argued that Tennessee's death penalty statute, as applied, was unconstitutional. Their main point hinged on the 1982 Tennessee Criminal Sentencing Reform Act, specifically TCA 40-35-102. This act, according to the defense, aimed to assure the fair and consistent treatment of all defendants by eliminating unjustified disparity in sentencing. Prior to this, juries sentenced across most crimes. But after 1982, judge sentencing became the norm for nearly everything except capital cases.
So the defense's logic was that if the legislature decided juries were inconsistent and prone to disparity in sentencing lesser crimes, it was manifestly unjust and unconstitutionally infirm to allow the same body to make the ultimate judgment call of life or death in capital cases. They're essentially saying the legislature, by implication, repealed jury sentencing for death penalty cases too, because if juries aren't reliable for theft, how can they be for murder?
Exactly. They also raised an equal protection argument, pointing out that capital defendants are uniquely required to proceed immediately to a sentencing hearing after conviction, unlike other defendants who get time for interviews and investigations. They saw this as a violation of equal protection and due process, given the stakes involved.
But the prosecution, represented by Mr. Flynn, didn't agree with that interpretation. How did he counter?
Mr. Flynn characterized the defense's comparison as apples and oranges. He argued that capital cases are inherently different. He pointed out that under the old system, jury sentencing wasn't a bifurcated process like it is now in capital cases, where the jury first determines guilt and then, in a separate proceeding, determines punishment after hearing additional evidence. He stressed that Tennessee has historically used jury sentencing in capital cases, and that while the Constitution doesn't require it, it certainly doesn't prohibit it either. He also highlighted the extra safeguards added for capital defendants, such as the Supreme Court's proportionality review, which involves extensive documentation for every first-degree murder case.
And on the defense's point about needing more time to prepare for sentencing, what was the state's response?
Mr. Flynn said that's precisely why capital cases are typically set further out than others, to allow preparation time. He added that if the defense genuinely couldn't prepare, they could file a motion to continue, which the court would consider. Ultimately, the judge, D. Kelly Thomas Jr., sided with the state, overruling the motion. He stated that carrying the defense's argument to its logical extreme would mean juries couldn't even determine guilt or innocence. He felt that the instructions given in death penalty cases, with their very well-defined choices, met concerns about uniformity, making the immediate sentencing phase constitutional.
So the death penalty challenge was unsuccessful. The next major hurdle was the motion for separate juries. This often comes up in cases with co-defendants. What was the defense's primary concern?
The defense, particularly for Mr. Sutton, argued that there could be evidence admissible against one defendant that would prejudice the other if they were tried together. Mr. Gibson used the impending motion to suppress as a primary example, suggesting that if evidence was ruled illegal for Mr. Dellinger, but potentially admissible against Mr. Sutton, it would create an irreconcilable conflict. They insisted on separate juries, citing Sixth Circuit cases that preferred this procedure to full severance, and even referenced the highly publicized Menendez trial, where separate juries were used.
It sounds like a logical argument for judicial fairness, but what was the prosecution's and court's perspective on this complex request?
Mr. Flynn called the idea of separate juries a logistical nightmare, a sentiment he felt was reinforced by the Menendez trial's complexities. He argued that the rules of criminal procedure already provide mechanisms for severance if prejudiced evidence becomes an issue, and the state would elect its options at that point, either moving for severance or choosing not to use certain evidence. The court noted that these issues typically arise in a brutal context, referring to a rule preventing the use of a co-defendant's confession against another. The judge ultimately overruled the motion for separate juries for trial. When the defense then requested a separate jury for the sentencing phase, Mr. Flynn upped the ante, calling it a prescription for a massive train wreck, emphasizing the redundancy and time it would consume to bring in new juries to rehear evidence. The court agreed, ruling it would not sit as a legislative body or state Supreme Court, and found the law on that issue very clear, overruling that motion as well.
With those major structural motions denied, the defense then turned to a motion for a bill of particulars. What was the goal of this motion?
This motion, filed in January 1994, was about gaining specificity regarding the charges. The defense for Mr. Sutton requested that the state clarify the facts it would rely upon to establish his presence at the crime scene, premeditation, and his exact role, whether he was a principal, an aider and abettor, or a facilitator. Mr. Gibson pointed out that two people can't pull the same trigger, and that the legal standard for proving premeditation had become stricter, citing a case where a co-defendant who didn't know about a gun was given a lesser offense. They argued the indictment was scanty and didn't provide enough detail for Mr. Sutton to adequately prepare for trial, especially given the seriousness of a first-degree murder charge.
So the defense wanted to know precisely how the state was going to classify and prove Sutton's involvement. How did the prosecution respond to this demand for more detail?
Mr. Flynn contended that Rule 7C of the Tennessee Rules of Civil Procedure, which governs bills of particulars, doesn't require the state to disclose every piece of evidence or its trial strategy. He argued that the defense already had extensive discovery, including the transcript from the previous trial in Sevier County, and that there was no question about the offense charged, the time, or the place. He argued they had everything they're entitled to and more. The judge partially agreed, ordering the state to file a notice specifying the date, time, and place of the alleged offense, but clarified that the rule didn't contemplate disclosing all evidence, which should come from discovery, not a bill of particulars.
That brings us to the motion to suppress evidence derived from a search warrant, which often turns on procedural details. What was the central dispute here?
The initial hurdle was standing. Did the defendants have the right to challenge the search? Mr. Sutton's counsel, Mr. Gibson, argued that while Sutton had no ownership interest, the search warrant itself, by naming James Dellinger as the property owner, conferred prima facie standing. Essentially, if the state sought to use evidence from that property against Sutton and the warrant stated it was Dellinger's property, then Sutton should have standing to object if the warrant was defective. The state, however, insisted that a defendant must show a reasonable expectation of privacy to have standing. The court clarified that the defendant has the burden to establish that expectation. It then ruled that Mr. Sutton, not owning the property, lacked standing to challenge the search warrant regarding Dellinger's property.
So Sutton was out of luck on that specific argument, but Dellinger's counsel, Mr. Dees, then presented his argument for Dellinger's standing, which proved more successful.
Correct. Mr. Dees argued that Mr. and Mrs. Dellinger owned both adjacent lots, using them for their mutual purposes and private benefit. He described the arrangement where their stepdaughter, Angela Gray, lived in one trailer, but it was an extension of the family home. Mr. Dellinger maintained both properties, paid utilities and taxes, had keys to both, kept tools there, did mechanic work, and had exercised the right to tell people to leave. The testimony painted a picture of communal living, even if separate trailers were involved, and that Dellinger had an expectation of privacy due to his dominion and control. Mr. Bailey for the state countered, arguing it was more of a landlord-tenant relationship, highlighting Dellinger's own testimony referring to her place and our place. But the court ultimately ruled that James Dellinger did have standing to challenge the search, finding that he exercised dominion and control over both properties, especially given Angela's status as a dependent daughter.
With Dellinger having standing, the court then moved to the substance of the motion to suppress the search warrant. Detective Jim Widener, the officer who procured the warrant, took the stand. What were the key elements of his testimony and the defense's challenge?
Detective Widener testified that the search warrant was issued by Judge Sexton. The affidavit supporting the warrant stated that Tommy Griffin was involved in a fight with James Dellinger and Gary Sutton on February 21, 1992, at approximately 7:11 p.m. The warrant authorized seizing a 12-gauge shotgun and Remington Peters shells. However, under direct examination, Widener admitted he didn't personally see the fight or know any witness who could identify the individuals by name. He also confirmed that no Remington Peters shells were seized from the property, and only a Mossberg barrel, not a full shotgun, was found, and it wasn't even listed on the return. The defense argued this raised questions about the warrant's validity, suggesting it allowed for a general search beyond its scope.
And the state tried to rehabilitate the affidavit during cross-examination, detailing the information Widener did have when he sought the warrant. What did that information consist of?
Mr. Bailey elicited testimony from Widener about statements from bartenders who identified Sutton, Dellinger, and Griffin at a bar, leaving together in a dark Camaro around 7 p.m. He also mentioned Cindy Walker and her husband seeing a fight on Alcoa Highway around 7:11 p.m. involving two men trying to pull a third from a dark Camaro. Another witness, Sharon Davis, observed a shirtless man staggering and a white male kicking around in the grass as if he was looking for something in the same area. Finally, Alcoa officers found Griffin shirtless, bruised, and intoxicated, stating he'd just had a fight with some friends. Widener affirmed he presented these facts to Judge Sexton under oath. The defense objected, arguing this was hearsay and an improper attempt to rehabilitate the affidavit beyond its four corners, which Judge Sexton relied on initially. However, the judge allowed the testimony to clarify the basis for Widener's conclusions, distinguishing between challenging the underlying facts an officer believed and the facial sufficiency of the warrant itself.
The entire exchange highlights the incredible complexity of pretrial motions, especially in capital cases, as lawyers navigate issues of constitutional rights, evidentiary rules, and legal precedent all before a jury is even selected. This is the kind of legal maneuvering that truly shapes the course of justice. If you found this discussion insightful, consider sharing this episode with a friend.